The motion to withdraw was already on the clerk's desk when Renata Cole pushed through the courtroom doors with the wrong file in her arms. Teddy Marsh was at the lectern, smiling the smile he used for judges he had once clerked under. The Honorable B. Hollings sat above him with her reading glasses already on, her pen already capped. 8 wage theft plaintiffs sat behind the bar in 2 crooked rows, hands folded, eyes on the partner who had told them only 6 weeks ago that justice was a slow river but a sure one. "Your Honor," Teddy was saying, given the irreparable breakdown in plaintiff's evidentiary posture, "Hartwell and Marsh moves to withdraw as counsel and consents to the defendant's renewed motion to dismiss the putative class for want of proof." Judge Hollings looked over the top of her glasses. "Want of proof, counsel. Want of admissible proof, Your Honor." Renata stopped at the gate. She had been a paralegal for 19 years, 4 firms, 2 custody fights, 1 tiny rented kitchen where her son did his homework on a folding chair. She knew the sound a case made when it was being walked out behind the courthouse and shot. She was hearing it now. Teddy turned, saw her, and the smile did not change. "Miss Cole, please wait outside. I have the file you asked for," Renata said. "Outside, please." Judge Hollings raised a hand. "Counsel, the court hasn't excused anyone. Miss Cole, what file?" Renata took 2 steps to the rail. Her voice was level. It had to be. Her son was sitting 3rd row from the back in his school polo, because the babysitter had canceled at 6 that morning and there had been no other option, and she could feel him watching her without turning her head. "The chain of payroll file, Your Honor, the one the firm was unable to locate last week." "I object," Teddy said. "To what?" Judge Hollings said. "I haven't heard anything yet." The opposing counsel, a woman in a navy suit named Quinn Pell, had not moved since Renata came through the door. She had the look of a person who had been about to receive a Christmas present and was now uncertain whether the wrapping had been tampered with. "Your Honor," Teddy said, "Miss Cole is a paralegal. She is not counsel of record. She is here in error. The file she purports to carry is firm work product, subject to privilege review, and the firm has already represented to the court that the relevant payroll records are unrecoverable due to the defendant's data retention practices. Anything miss? Cole says about that file is, with respect, outside her authority." "With respect," said Judge Hollings, who had used that phrase for 31 years and knew exactly how much weight it could carry. "I'll decide what's outside. Whose authority in my courtroom? Miss Cole, come through the gate." Renata pushed the little wooden gate. It made the sound it always made, small, dry, definite. She set the file box on the empty plaintiff's table beside Teddy. She did not look at him. "Identify yourself for the record," the judge said. "Renata Cole, Your Honor, paralegal, Hartwell and Marsh since 2007. Lead paralegal on Reyes Ortega versus Crestline Logistics since intake." And the file, Defense Exhibit 17, returned to plaintiff's custody on April 19th by court order, never logged into firm records. "I located it in the basement archive at 6:18 this morning under the prior matter number from the consolidated case." The smile finally left Teddy's face. He had a way of straightening his tie that meant he was going to say something later that would cost someone their job. Renata had seen him do it to a junior associate, a courier, a copy clerk's son. She watched him do it now, and did not blink. "Your Honor," Teddy said, "I have not had an opportunity to confirm authenticity. I object to the introduction of unverified material at a motion hearing where my client has already moved to withdraw." "Mr. Marsh," the judge said, "your client is the class. The class has not moved to do anything. You have. Counsel for the defendant, where do you stand on Mr. Marsh's withdrawal?" Quinn Pell rose halfway. "Defendant takes no position on plaintiff's counsel's internal affairs, Your Honor. Defendant continues to maintain that the payroll records do not exist in recoverable form, and that without them, class certification fails for predominance." "Understood." Judge Hollings turned to Renata. "Miss Cole, you are not counsel of record. I will not take argument from you, but I will take a witness. Are you prepared to be sworn as the custodian of these records?" "Yes, Your Honor." "Then come around." Teddy made one more attempt. "Your Honor, this is highly irregular." A motion to withdraw is not the proper vehicle for an evidentiary hearing. You filed a motion that asks me to dismiss 8 people's claims with prejudice, counsel. I'm going to make sure the record is clean before I do. She looked toward the back. The young man in the green polo. Are you here with Miss Cole? Renata's heart kicked once. Her son's voice, 14 and trying, came clear and unembarrassed. Yes, ma'am. I'm her son, the babysitter canceled. Then you sit quietly and you don't worry. Court appreciates you being here. Bailiff, would you bring the young man a glass of water? Judge Hollings turned back to the front, and her voice carried the same plain courtesy without changing register. Miss Cole, please come around and be sworn. Renata walked to the witness box. She did not look at Teddy. She did not look at the plaintiffs. She looked at the small, worn brass plate on the rail of the witness box, and she put her hand on the book, and she swore. She had typed thousands of these oaths into the record. She had never once said them out loud. Miss Cole, tell the court what is in that file. Original time cards from Crestline Logistics Whitfield Distribution Center, dated January through August of last year, for 83 warehouse associates, including the 8 named plaintiffs. The cards are stamped in and out by the time clock kiosk that the defendant decommissioned in September. The timestamps show shift hours worked that exceed by an average of 9.4 hours per week the hours recorded on the defendant's payroll spreadsheets for the same employees. How do you know the spreadsheets? I built the comparison, Your Honor. Spreadsheets were produced in discovery on March 3rd. Time cards I recovered this morning. And how did you recover them? In 2022, the firm represented Crestline Logistics in an unrelated subrogation matter under a different case number. At the conclusion of that matter, the file room received 4 boxes from the client's outside vendor. 3 boxes were returned. The 4th box, mislabeled, was logged into our basement archive under the closed matter number for the subrogation case. The 4th box contained the time clock backup cards. Quinn Pell was on her feet now. Your Honor, that's privileged work product from a prior representation. We have a clear conflict question. Plaintiff's counsel cannot use material from a prior engagement against the same former client. I move to exclude. On those grounds. Immediately. That is an interesting motion, Miss Pell, Judge Hollings said. It would be a much stronger one if your client had not produced those very records to plaintiff's counsel 6 weeks ago in response to request for production number 11. Mr. Marsh, did your firm produce those time cards on April 19th? Teddy did not answer. He looked at the file box. He looked at Renata. He looked at the patch of carpet between his shoes. Miss Cole, the judge said, did the firm produce these cards on April 19th? No, Your Honor. The firm produced a stipulation that the cards were unrecoverable. I drafted the stipulation. I drafted it because Mr. Marsh told me the cards were unrecoverable. Yesterday at 5:40 p.m., Mr. Marsh asked me to begin destruction of the closed matter archive in the basement, citing storage costs. The destruction order is in his email at 5:42. A small, dry sound came from the back row. One of the plaintiffs, a woman with the kind of hands that had not been still since she was 7, had said something under her breath in Spanish. The interpreter at the side table closed her eyes for 1 second and opened them again. Mr. Marsh, Judge Hollings said. Teddy's voice came thin. Your Honor, the email is being mischaracterized. The instruction was for routine purge of expired matters under the firm's records retention policy. Miss Cole is Miss Cole. Has personal reasons too. Be very careful, counsel. The room held still. Miss Cole, the judge said. Are you employed by Hartwell and Marsh as of this hearing? Yes, Your Honor. Mr. Marsh sent me a termination letter at 7:12 this morning by courier. I have not signed receipt. The firm's bylaws require a 48-hour notice and a written reason. The letter cites neither. That is between you and your employer. The court is concerned with these time cards and with Mr. Marsh's motion to withdraw. Miss Pell, did your client produce these cards? Quinn Pell sat down slowly. She had the look of a person who had just learned which way the wind was about to come from. Your Honor, I will need to consult with my client. Take 5 minutes. She did not take 5 minutes. She took 2. When she came back, her face had the particular composure of a lawyer whose client has just stopped listening. Your Honor, My client maintains that the cards in question were never in their custody at the time of the production request. My client further maintains that any time clock data from the Whitfield kiosk was, quote, regrettably overwritten in the ordinary course of business, end quote, in February of this year. February, Judge Hollings said. Yes, Your Honor. After the cards were produced to Hartwell and Marsh in the subrogation matter in 2022. My client takes no position on what was produced in unrelated prior matters, Your Honor. I bet they don't. The judge took her glasses off, set them on the desk in front of her, and folded her hands on top of them. The court reporter's keys did not stop. Miss Cole stepped down. Mr. Marsh, sit. Renata stepped down. She walked back to the plaintiff's table. She did not sit. The 8 plaintiffs in the rows behind her were looking at her now in a way she had felt only twice in 19 years. Once at her son's first parent-teacher conference. Once at her grandmother's wake. She kept her shoulders square. The court finds the following on the present record. Judge Hollings said, 1. The defendant produced documentary evidence responsive to request for production number 11 on April 19th in the form of original time clock cards covering the class period. 2. Plaintiff's counsel of record had constructive custody of those cards from April 19th forward and either failed to log them or affirmatively misrepresented their existence. 3. Yesterday afternoon, plaintiff's counsel of record issued a written instruction to destroy the archive in which those cards resided. 4. The defendant has represented to this court twice that the underlying time clock data was overwritten in February, a representation that cannot stand against the physical cards now before the court. She paused. She looked at Teddy. She looked at Quinn Pell. She looked, longest, at the 8 plaintiffs. Mr. Marsh's motion to withdraw is denied. The defendant's renewed motion to dismiss is denied. The court, sua sponte, certifies the proposed class under Rule 23, subdivisions A and B, 3, finding numerosity, commonality, typicality, adequacy, and predominance, amply demonstrated by the production now before it. Class counsel will be addressed in a moment. On the matter of sanctions, the court finds clear and convincing evidence of spoliation by the defendant under the inherent power of this court. An adverse inference instruction will issue at trial. The court further finds clear and convincing evidence of misrepresentation to the tribunal by plaintiff's counsel of record, specifically Theodore Marsh, in the April 19th stipulation and the May 22nd status report. Mr. Marsh is referred to the State Bar's Office of Disciplinary Counsel for investigation. The firm of Hartwell and Marsh is hereby sanctioned in the amount of $50,000 payable to the class fund, jointly and severally with Mr. Marsh personally. She turned a page. On the matter of class counsel, Ms. Cole, the court is not in the habit of certifying paralegals as counsel of record. The court is, however, in the habit of certifying counsel who can be trusted to litigate a class fairly and competently. The court directs the clerk to contact the Workers' Rights Law Project this afternoon and to invite their senior trial team to enter an appearance as substitute class counsel, with the express direction that Ms. Cole be retained on the matter as lead investigator under their supervision, at a rate to be approved by the court and paid from the eventual class recovery. A small movement in the back. The plaintiff in the second row had put her hand over her mouth. On the matter of Miss Cole's employment, the judge said, that is, as I noted, between her and her employer. But I will say this for the record. A paralegal who walks into this courtroom carrying evidence that her own partner has tried to bury, knowing exactly what it will cost her, is a person this profession is privileged to count. Mr. Marsh, you will not retaliate. Any termination decision you have made or are inclined to make will be examined by this court and by the State Bar with the most exacting attention. Are we clear? Teddy said, very quietly, Yes, Your Honor. Speak up, counsel. Yes, Your Honor. Bailiff, mark the time. The bailiff looked at the wall clock. 9:43, Your Honor. For the record, then, Miss Cole came through that door at 9:02 with a box. At 9:43, this court has certified a class of 83 workers, sanctioned a firm and a partner, referred a member of the bar for discipline, and arranged competent counsel. 41 minutes. She looked at the plaintiffs. I owe you 8 people an apology for the years this took. I cannot give back the wages. I can give you a fair trial. We will set a scheduling conference for 2 weeks from today. The court is in recess. The gavel came down once, soft and final. Renata did not move at first. The plaintiffs rose. The woman who had put her hand over her mouth came through the gate without asking and took Renata's hand and held it. She did not speak. She did not need to. The interpreter stood and turned her face away for a moment and then came back composed. Teddy walked out without his briefcase. He left it on the table. A junior associate picked it up and followed him at a distance. The associate had probably been waiting 8 years to feel entitled to. Quinpel crossed to the plaintiff's table. She did not extend her hand. She said, "Low. I was going to win this morning. I am glad I did not." Then she walked away, and that too was something. Renata's son came down the aisle with his glass of water still untouched. He set it on the table beside the file box. He was 14, and he had watched his mother sworn in a courtroom and stand and tell the truth in front of a judge and a partner and 8 people who had been told for years that what they knew about their own hours did not count. He looked at her the way she had once looked at her own mother the night her mother came home from the 3rd job and quietly said, "No, we are not moving out of this apartment. Not tonight, not ever." Renata allowed herself one small breath and put her hand on the back of his neck for 1 full second before she turned to gather the file. In the hallway, the senior trial counsel from the Workers' Rights Law Project was already on the phone. He introduced himself to Renata in the corridor. He said, "We have heard your name for years." He said, "We would like to meet at one." He said, "You will not be paid a paralegal's rate on this case." He said it the way Judge Hollings had said, 41 minutes. The 8 plaintiffs walked out together. They had come in apart, in 2 crooked rows. They went out as a class. In the elevator, alone with her son and the file box, Renata Cole felt, for the first time in a long time, that the building she worked in was one she belonged in. Not because of the firm, because of the floor below it, where a judge had taken 5 minutes to apologize for the years, and a paralegal with the right file, and her son in the 3rd row had walked through a wooden gate and had not waited to be asked twice. Her son, looking at the floor, said, "Mom?" "Yes, that was the right thing." "It was," she said. And it was, and the record would say so. In 9 pages of transcript, and 1 order of sanctions, and 1 certified class of 83 workers who would, by the next Friday, begin to receive notices in 2 languages, telling them that the hours they had worked had been counted, and the hours they had not been paid for would, lawfully and on the record, be returned to them in full.